Okay, stock options, retirement accounts. I heard filing for divorce, it's easy. Not really. Okay. There are 4 ways to get divorced, not just one, really? Huh. Default, what? Contested, uncontested, with and without a hearing. Can someone explain it to me? This is really, really interesting. Okay, let me call Diana.
There are several different ways to get a divorce judgment. The first 2 ways are called a default and a true default judgment. A default divorce is another way of uncontested divorce. The third is a judgment with an agreement, and the last one is without an agreement, with possible trial or contested divorce. Let's start with the 2 default judgments first. Number 1. The first way is the default judgment with an agreement, with so-called marital settlement agreement. If you serve your spouse and there are no response for 30 days, but you both reach an agreement. The main reason for agreeing on a default is that it doesn't have to involve a court process. In that case, the filing spouse can take care of the paperwork and you save the filing fees. Second case of a true default requires first that your spouse had not responded to your petition for dissolution of marriage. Second, you properly served all the forms as explained in my previous video. Third, then after waiting for 30 days, starting with service to your spouse and completing all the steps for service, the financial disclosure forms, you can file for a true default judgment. Before you file for the default judgment, make sure to fill out a declaration of disclosure, income and expense declaration form, and a schedule of assets and debts form, and have them served on your spouse. The other 2 ways to finish a divorce are if respondent, meaning your spouse, if you initiated divorce, files a response. In the first one, you and your spouse have an agreement. You both must complete and serve the same financial disclosure documents to each other. The respondent will have to serve on the petitioner within 60 days of filing the response. In the event of your spouse filing a response and you both reach the written agreement, either party file appearance stipulation waiver forms in the proposed judgment with written agreement attached and the other needed forms. If your spouse files a response, but you both are not able to reach an agreement, the court may try to reach an agreement. Otherwise, parties must go to trial. I suggest to seek a good family law mediator to help you and your spouse to reach an agreement and avoid expensive court battles. In our next video, we'll talk about the mediation and collaboration. Thank you for your attention.